Imagine it's a random Tuesday, calendar's full, coffee's cold, and then bam, a lawsuit lands in your inbox. In 48 hours, opposing counsel knows your bank, your business, your equity, even your boat slip. The question is, can they take it? So keep watching, and I'll give you the answer. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. And for 34 years, I've helped high net worth clients, business owners, and real estate investors in the US and around the world keep what they've built. And for nearly 30 of those years, I've been setting up Cook Islands Trusts. Our organization has set up more Cook Islands Trusts than any firm in the world. And that's not a flex, that's context, because today I'll show you exactly how these trusts work and why they're the gold standard for a lawsuit defense without the fluff. Now, quick ask, if learning the actual legal mechanics that protect wealth, not hype, is your thing, subscribe now and tap the bell. You'll get the strategies the top firms charge to explain. And also, if you're already thinking, I need this, feel free to visit assetprotectionplanners.com. You'll get a whole lot of free information as well as a confidential consultation. All right, level set. The U.S. legal system, phenomenally good at enforcing judgments, was not designed to safeguard your net worth. Judges are paid to resolve disputes, not preserve your lifestyle. If a plaintiff wins or even freezes your accounts during litigation, your choices evaporate. We talk every week with affluent owners who delayed, and their logic is, I'll wait and see. And then a lis pendens hits, or a prejudgment remedy freezes their assets. At that point, you've gone from chess player to chess piece. Key truth, asset protection is about jurisdiction and timing. Put assets behind the right legal fence before the wolves are at the door and the wolves go hungry. Wait until they're at the table and they take Thanksgiving dinner right off your table in front of you and your family. Okay, now here's what a Cook Islands Trust actually is. No hype, just law. Definition. A Cook Islands International Asset Protection Trust is a civil law legal tool formed under the International Trust Act, Cook Islands, a statute expressly engineered to resist foreign judgments and stack legal defenses in favor of the settlor, that's you, and your beneficiaries, typically you and your family. Now, what it's not a tax dodge. U.S. taxpayers still file and pay on trust earnings. It's not a way to launder money or outrun lawful orders. It's a defensive wall that rebalances power when someone aims litigation at you. Core advantage, why it's the gold standard. First of all, jurisdictional firewall. U.S. court orders have no automatic force in the Cook Islands. A creditor must start over there under Cook Islands law with higher burdens, shorter limitation periods, and no contingency fees. Short statute of limitations. It protects assets right away, plus fraudulent transfer claims face tight deadlines and high standards of proof. Much stricter than U.S. states. Professional trustees. Licensed bonded trustees headquartered outside the reach of U.S. courts mean your assets aren't controlled by a U.S.-based trustee who is someone a U.S. judge can jail tomorrow if he doesn't comply. The result? You turn a local scuffle into an international gunfight, one most plaintiffs won't fund. Okay, so what if a U.S. judge orders you to repatriate or bring back the assets? Can they force your hand and throw you in contempt if you can't bring the funds back? Now hold that and I'll answer after we lay the structure that keeps you comfortable in calm waters and protected in storms. Okay, the structure, trust plus LLC, which is why you stay in control. So here's how we structure the most elite plans, tailored to your facts. Now, first of all, the Cook Islands Trust is right here, represented by this purple box. Now, the Cook Islands Trust owns 100% of a Cook Islands LLC. So why do we structure it that way? Because the LLC inside of the trust gives you a tool that you can control, and the LLC owns the bank account. So when a U.S. court orders you to hand over the money, our licensed bonded trustee company law firm can step in for you as manager and they are licensed, bonded in the most regulated jurisdiction in the world, and the U.S. court say, give me the money, and our offshore law firm says, sorry, you don't have jurisdiction here. So that's the crux of how this structure protects your assets. So again, you're manager of the LLC when the seas are calm, meaning you can invest, sign, move funds to approved accounts, operate, so it feels like normal life. Now, the magic, like we talked about, when a lawsuit hits, the trustee, which is like we say, a licensed, bonded Cook Islands law firm, can temporarily replace you as the LLC manager, only if needed. So that's the storm mode. So it's not personal, it's protective. The trustee company operates under your trust deed's rules and fiduciary duties. When the storm passes, the management reverts back to you as allowed by the trust. So the architecture allows the biggest emotional objection wealthy people have: do I lose control? So the answer is no. That's why we set it up this way with the LLC inside of the trust. You operate day to day. The trustee steps in only when necessary, when the courts would take all the money. And they do that to shield assets from hostile court orders. So think of it as a safety pilot. You fly, they take controls during a stall. Okay, so let's talk about this little piece in here, the bank account. The bank account inside the LLC. So we'll answer the question, where does the money live? Cash and securities, typically custodied at reputable banks and brokerages that can follow trustee instructions in storm mode. We often do this in Switzerland. There's also great banks in Liechtenstein and Luxembourg and Cook Islands itself. Operating company interests. Now, membership units or shares can be held by the trust, often via the Cook Islands LLC. Also, your operating business. What we do is we record UCC1 liens against your corporations, your LLCs, payable to the Cook Islands LLC. Now, if needed, we get a third-party lender to purchase those liens and put your proceeds in the offshore trust. So everything you have in the U.S. is encumbered, which brings us to what we do with U.S. real estate, which is very similar. It's held or encumbered strategically, and more on that soon. So with this setup, domestic judges can shout orders, but the trustee, which is governed by Cook Islands law, isn't compelled to obey. So that's the point. We've had a client say, gosh, the judge just threw up his hands and said, sorry, there's nothing I can do. I don't have jurisdiction over those people. And the plaintiff just walked out of the courtroom with their head held down. Nothing they could do. Now, here's an answer to a question we asked earlier. Repatriate or else. Could a U.S. judge order you to bring back or repatriate the assets? And the answer is yes, they could if they believed you had the current power to comply and refuse. That is, they could potentially do it. But at that point, the way we set it up, you don't. So that's why the structure matters. In storm mode, you no longer pull the levers. The trustee can step in to protect you as the LLC manager and the accounts. So the reason why it protects you is you can't repatriate what you don't control directly, and the judge can see that you don't control it directly. So properly drafted, this removes your present ability to comply. And that legal shift is the difference between risk and resilience. So see why we do this. That's why we put the LLC inside of it, because that gives you something to control while the waters are calm, and the same lever that you can hand to our offshore trustee company law firm to protect you when things get stormy. Here's a critical note. This isn't about hiding. It's about lawful separation of powers that you implement before a court freezes you. So this is using strategy. This is using the law in your favor. So let me share a case study with you. A Florida medical practice owner with an $8.5 million net worth faced a bitter partner dispute and malpractice claim. So we placed the liquid assets under the Cook Islands Trust with the Cook Islands LLC holding that account. He managed the LLC for 2 years, calm seas. When litigation escalated, the trustee assumed the manager role of the LLC for 9 months. Opposing counsel threatened, "We'll get it all." Well, they didn't. So settlement number plummeted because they had no leverage. Here's the lesson. Plaintiffs settle on realities, not wishes. So change the reality and you change the outcome. You put yourself in a better position. Here's case study B. A California developer had multiple properties with substantial equity. So we did land trusts for privacy, stateside LLCs as the beneficiaries of those land trusts for liability and compartmentalization, and equity stripping via credit line mortgages in favor of the client's Cook Islands LLC. So when a contractor claim turned into a lawsuit, the paper equity was mostly gone from sight. A third-party lender later purchased the subject liens, moving the proceeds into the offshore trust structure. Here's the lesson. For U.S. real estate, equity management, equity stripping, beats ownership gymnastics. Here's a public lesson. Domestic trusts remain exposed to U.S. judges and U.S. discovery. Cook Islands law imposes heavy proof burdens, short deadlines, and doesn't recognize U.S. judgments automatically. So poor drafting or role selection, for example, making you a powerful protector who can direct the trustee, can undermine the plan. So that's the reason why you want to use specialists. In fact, like I say, we've set up more Cook Islands Trust than anybody, so we know where the landmines are and we know where to step and where not to step. Here's cliffhanger number 2. But what about fraudulent transfer? Is it moving assets into a trust illegal if you've got a lawsuit brewing? Well, that's a great question. And here's where skinny internet takes cause fat legal problems. In fact, I'll answer precisely after we clarify real estate, the most common trap for U.S. owners. Okay, now let's talk about real estate asset protection, privacy, equity stripping, and practical steps. Okay, first of all, privacy with land trusts. For 1 to 4 unit residential rentals and similar parcels, a land trust owns each property. So that's the first layer, is the privacy level. And this helps keep your name off the public title. The beneficial interest of each land trust is owned by a dedicated state-based LLC. That's where the LLC falls in right here. So you have privacy by the land trust and you have protection with the LLC. Often one LLC per property, so they don't all fall down like a bunch of dominoes if there's a lawsuit of one property. So privacy does not equal protection, but it reduces targeting. So number 2, liability silos with LLC. So let's say a tenant sues over property A. We want properties B, C, and D to be protected from that lawsuit. And we want it to be walled off, and separate state LLCs with land trust as beneficiary act as those walls. Number 3, equity stripping. There are 2 steps. Step 1, most common, your Cook Islands LLC, this LLC down here, records mortgages against each of the properties. That is a mortgage or deed of trust some states use. If with a legitimate lien with a promissory note and security instrument, no cash moves at this moment. Publicly, the property looks highly encumbered and less attractive prey. Step number 2, occasionally, if a dispute intensifies, a third-party lender can purchase one or more of these liens here, and we put the proceeds into your offshore trust structure. See how these things work together. And now it's not even you that's owed, it's an independent lender. So, question, why don't we put the property straight into the Cook Islands Trust? And the reason is this, because a U.S. judge says, great, you have that fancy trust. I don't really care. The real estate's under my jurisdiction. I'm going to take it anyway. But what we do here is we protect it from the top, we protect it from the bottom, we protect it from the inside so that there is no equity left in the property. So that value to seize it and sell it and get the proceeds and stick it in their own pocket, that's already gone because you've already stripped it out. Here's a cravat. Respect the homestead rules. Some states offer strong primary residence protection, so we tailor that accordingly. Record real documents. So this isn't cosplay law. So we want to go ahead and value the liens responsibly. We don't want to over-encumber absurdly because a judge will see right through that. And courts can sniff theatrics. So here's the outcome. The attack surface on your U.S. real estate shrinks. Plaintiffs pursue collectible targets, and you're not one. So here's the answer to the cliffhanger we left before. Fraudulent transfer, what it is and what it isn't. So here's the definition in plain English. Fraudulent transfer is typically a civil claim, not a criminal one. It has that F word in it, but it's a civil matter, not a criminal matter in almost all cases. And it alleges that you moved assets to avoid paying a particular creditor. So it's not you committing fraud in the everyday sense. It's a creditor remedy with specific elements that they must prove and time limits they must respect. Here are the key realities. Timing matters. The earlier you plan, the better your defenses. So a well-drafted Cook Islands Trust does not crumble just because a creditor screams fraudulent transfer in a U.S. courtroom. The fight must be taken next to the Cook Islands, where standards are higher and the clock ticks differently. Asset protection does not equal asset evasion. It's lawful risk management when done before orders and without the intent to defraud. So the bottom line here is don't let internet folklore paralyze you. Make sure you get the truth from people who have experience. Properly crafted plans done early work. Okay, now let's talk about how this all comes together. Liquidity and operating companies, what goes where. Liquid assets, such as cash and security, typically the first move under the trust umbrella via the Cook Islands LLC. So the Cook Islands LLC holds those bank accounts. So they are portable and easy to defend offshore. When we set up an offshore account in the Cook Islands LLC, what owns the Cook Islands LLC again? The trust. The trust owns 100% of the Cook Islands LLC. So the Cook Islands Trust owns the Cook Islands LLC, like we have in this illustration. Operating company interest. Often we keep day-to-day ops onshore for practicality. Payroll, vendor payments, licenses. The ownership of those entities can be structured in such a way that we strip out the equity, record liens against your interest in your business payable to your offshore LLC, which in turn can be purchased by a third-party lender and the proceeds put offshore. So that way your business is stripped clean of its equity and your business is protected as well. Similarly, intellectual property can also be encumbered, or it can simply be held separately and license-backed, fact-specific, and tax-sensitive. Banking. Choose risk-calibrated banks comfortable with trust structures such as the Swiss bankers that we use. So expect KYC, know your client. They're going to have to know your background so that you're not a terrorist, and anti-money laundering law, so they track the source of funds so they know they're not laundering drug money, things like that. So that requires proof, just like walking through the body scanner at the airport. You're a good person, but they don't know that, so that's why they want your background, make sure the source of funds is legal. Proof of address, passport copy, professional references, and so on. So it's normal. In fact, our team actually shepherds you through this with templates and checklists. We get you on a video call and we walk you through it after you become a client. Okay, business guy, but what if a trustee goes rogue or refuses to follow my wishes? Excellent question. I'm glad you asked it because this is where governance separates pros from dabblers. Trustee safety, governance, and your peace of mind. Let's address that. First, we use licensed bonded Cook Islands trustee law firms. So this is not Uncle Larry with a stamp. Fiduciary duties are statutory. The regulators are on them like white on rice, and malpractice exposure is real. Their business model lives or dies in reputation and compliance. In fact, if there was even one case of something hinky going on in the Cook Islands, it would be all over the internet and the industry would be done. So they're very, very strict on compliance. Your control in calm seas. So as manager of the Cook Islands LLC, you transact normally. So that's 90 to 99% of your financial life. Storm protocols. When litigation hits, the trustee can assume the management of the LLC. So they act per the trust deed under the supervision of the regulators who are very, very strict and not their personal whim. So you can include investment guidelines. You can have co-signatory requirements for large moves in calm seas, and other guardrails in place with protectors and so on. Changing trustees. A properly drafted trust deed allows for trustee replacement. So you can change the trustee, not during active contempt risk. Therefore, you're not locked in for life to one institution's brand of coffee. Okay, here's the answer to cliffhanger number 3. A legitimate Cook Islands trustee is regulated, insured, and bound by fiduciary duty. So the trust deed plus the law is your contractual and statutory safety net. Rogue behavior is both improbable and legally actionable. In fact, I've been doing this for 30 years. I've never seen anything but perfect integrity. Okay, let's talk about costs versus consequences. That is the rational math behind this all. High net worth defense is a numbers game. Okay, consider this. Average defenses of a serious civil case can exceed 6 figures. One adverse judgment can wipe out decades of compounding. So that's why a Cook Islands trust with proper architecture typically costs a tiny fraction of the risk that you face. So ask yourself, what's the cost of doing nothing? If the answer is potentially millions, then protecting yourself before the storm is the adult move. Okay, here's what happens next. We inventory assets, liabilities, risk vectors, residency, and litigation status. Here's the design. The trust deed we draft, the LLC structure, We do the banking plan and U.S. real estate treatment, land trust, LLCs, equity stripping. Next, we go to the KYC onboarding, the proof of address, passport copy, bank and law reference letters. So we provide templates and concierge support. So we walk you through this on a video call. So we handhold you through the whole process. Funding. You move liquid assets under the Cook Islands LLC ownership into the bank account, aligning operating entity ownership as appropriate. Real estate. We record liens where indicated. We coordinate any third-party lien purchases if escalation occurs. Governance and management. Annual reviews. Alignment with tax advisors. We keep the structure simple to operate, but hard to attack. So if you're in that $1 million to $20 million plus range, business owner, real estate heavy, or simply visibility rich, and you want the peace of mind of jurisdictional strength, feel free to talk to us at assetprotectionplanners.com. I'm the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. My team and I have been doing this for 34 years, and for nearly 30 of those, specifically with Cook Islands Trust. And like I said, we've set up more of these than any firm in the world. So this is where we quietly professionalize your defense so that you can go back to building, living, and yes, sleeping. Okay, now time for a quick question clinic. Is this aggressive? And the answer is no, it's defensive. You still pay taxes, report income, and follow the law. You're just choosing a venue that respects your property rights. Okay. My domestic trust is enough. Well, maybe, until a domestic judge compels your domestic trustee to hand over the assets or face contempt. Offshore is about breaking that chain. Okay, next. I'm worried about fraudulent transfer. Great. So start before the dispute, or at least before the freezes. In any case, Cook Islands law sets a higher bar for creditors and shorter clocks. Okay, what if I need money quickly? Calm seas, you manage the LLC. Stormy seas, the trustee executes your reasonable, lawful requests in line with deed provisions. So liquidity planning is part of the design. Will my bank freak out? Well, quality banks know this space. Expect more documentation, not less. So that's a feature, not a bug, and that protects you. So here's the quiet truth wealthy people already know. You visibly own nice things. Multiple properties, boats, successful companies. You're already a target. Plaintiffs choose defendants with collectible assets. A Cook Islands Trust flips that script. You still enjoy the assets, but your collection path becomes steep, expensive, and uncertain. So most rational adversaries walk away or settle with your nuisance number. So that's why serious families use this structure, not because they expect lawsuits, because they respect risk. Okay, so here's a closing thought, not hype, but reality. I've watched careers nearly ended over a single judgment. I've watched clients with proper Cook Islands planning win by not being collectible. Judges judge, plaintiffs sue. Your job is to prepare. And you've heard it said before, the best time to plant an oak tree was 20 years ago. The second best time, it's before you're sued. So if this resonated, subscribe for more deep dive legal strategy and for a private design session, zero fluff, go to assetprotectionplanners.com. Let's put your name on the title page and not the target list.